You're listening to 15 Minutes, where we feature community leaders sharing what the rest of us should know but likely don't. Hi, Chad Franzen here, one of the hosts of Share Your Voice, where we get to talk with top-notch law firms and lawyers about what it takes to grow a successful law practice. This episode is brought to you by Gladiator Law Marketing, delivering tailor-made services to help you accomplish your objectives and maximize your growth potential. To have a successful marketing campaign and make sure you're getting the best ROI, your firm needs to have a better website and better content. Gladiator Law Marketing uses artificial intelligence, machine learning, and decades of experience to outperform the competition. To learn more, go to gladiatorlawmarketing.com, where you can schedule a free marketing consultation. Manali Arora is an employment litigation attorney representing plaintiffs who face workplace discrimination and wrongful termination. She's a partner at Swartz Swidler, representing clients at all stages of litigation, from administrative claims at the EEOC level to federal court cases. Hey, Manali, thanks so much for joining me today. How are you?
I'm doing well. How are you?
Great, thank you. Hey, so tell me a little bit more about Swartz Swidler and what you guys specialize in.
Sure. We specialize in representing plaintiffs in all types of employment matters. So we do represent individuals. We represent them at all stages. So administrative claims against their employers at the EEOC. Those are anti-discrimination. EEOC is tasked with enforcing the anti-discrimination laws under the ADA and Title VII. So employees facing disability discrimination, racial discrimination, pregnancy discrimination, those are all often begin at the EEOC level, but we do proceed with those claims through litigation. We also represent plaintiffs in larger class actions, and those are generally in wage and hour. There are many times when employers are not practicing or not paying employees appropriately in accordance with wage and hour laws, and it results in sometimes small changes to an employee's paycheck. They're taking $1 here and there, but it is a large savings for the employer. And we are trying to remedy that and ensure that all the money that employees are due comes in their paycheck to them through wage and hour class actions.
You listed a number of types of kind of discrimination. Can you give me maybe an example of some of those?
Sure. There are many claims to be had, but often, for example, an employee comes in and she says, I'm pregnant, I'm going to be needing a leave of absence beginning in 2 months. And, this isn't a workplace that's pretty relaxed. People come in 9:05, 9:10. All of a sudden, this employee is getting written up every time she's a minute late. And it only started after she told them she was pregnant. There's a big project on the horizon. It's a pain for the employer to train somebody to take over for this employee, and they're fired for 5 latenesses. Leaves you scratching your head. You wonder, what was this really the reason they were fired? Lots of people are coming in a little bit late, and I never had a lateness issue all the time I was there. All of a sudden I'm pregnant. They have an issue, there's a project on the horizon. Those are the kind of claims we take. Employers are sophisticated. They're never going to tell you, I'm going to fire you because you're pregnant. Or there's never going to be a boss who says, I don't like you because of your race. But unfortunately, in this world, that still occurs. And our job is to try and help show employers that there's consequence for doing that. And that's why we bring these claims, not only for the individual, but try to change the institution as a whole and make sure that these laws are enforced.
What are some things that employees should be aware of regarding their rights, especially concerning policies that could be outdated?
Particularly considering outdated policies, I tell employees the best thing you can always do is make a paper trail of your claims. If you have a question about a policy, let's say, for example, an issue that's come up a lot is workplaces have a zero tolerance drug policy, but you have a medical condition and you have a medical marijuana card. And I would make sure you tell not just your boss, who might say, that's fine, it's really not going to be an issue, but make a copy of your card, email it to human resources, and also keep a copy for yourself so that you have made it clear, hey, this policy shouldn't be implemented against me because I have a medical reason why I may fail these randomized drug tests, but I'm allowed to by the laws of the state, and I'm prescribed this for a disability. that way, if later down the line they say, oh, it had nothing to do with the drugs, it was because this employee started a fight on the warehouse floor. Well, sure, but if you can prove I told them that very morning and now they're alleging this, it's a lot easier to prove the employer's coming up with a reason. Um, you give them notice and all of a sudden you are chosen for the random drug policy, or the random drug test. If you have a written record and some proof of when you've notified the employer of your disability, of a pregnancy, of a medical marijuana card, it makes it much easier to enforce those rights.
Are there some resources available to employees to ensure enforcement of their rights?
Well, a lot of research. I mean, there are publications out there. We put out publications on our website, but really, what employees can do, EEOC is a great resource. You can always call them. Often, law firms such as ours don't get involved with cases where it's just a minor skirmish. You're not
Mhm.
sure what your rights are. You're asking HR. You're not sure they're giving you the right answer, but you haven't been fired. There isn't an action taken against you. Always call an attorney. Sometimes we're just happy to give you advice on what you should do in case things go awry. But EEOC is a wonderful resource as well, particularly when it comes to anti-discrimination claims, um, race, religion, national origin, as well as disability.
Does your firm typically represent clients after they've left the company that they're in a dispute with?
Generally, I mean, unfortunately, the laws have not are fully caught up with, well, state this another way. Unfortunately, the only remedies that a lot of these laws provide are emotional distress as well as lost wages. And so sometimes what employers do, because they're smart and sophisticated, as I've said, is sort of harass you to the point where you just quit. And now you don't have any lost wages because you haven't been fired. Um, so it's always good to reach out to an attorney if you have a question, you feel like you're being harassed, um, for an unlawful reason. It's always good to reach out to EEOC. You can file a charge with EEOC. They may seek to enforce your claim, even if you haven't been terminated, because they are the government agency that's tasked with doing so. Um, I will tell you the best resource that employees have, and unfortunately, it's a diminishing resource, is a union. If your workplace has a union, that's the best place to go. And I find that workplaces with unions are much more likely to stand up for an employee before things get too far down the line.
What is it about employee litigation that you particularly enjoy?
I think that it's difficult to stand up to big corporations. I think that it's difficult for much of our society. They feel like they don't want to be they're not sure, they don't know if they have the money. It's intimidating to go into a courtroom and face a judge. But really ensuring that everybody is treated fairly in their workplace and paid appropriately, it is what's important to keep our society going. And I feel like our job is to help the individual and try to help level the playing field to ensure that that continues.
How did you kind of choose that as your field within the legal industry?
I came about it in a little bit of a roundabout way. After law school, I actually worked for the Federal Energy. I mean, after college, I worked for Federal Energy Regulatory Commission. I was doing energy oversight with the government, and it's a very honorable job. They do a lot of important things over there, but I just didn't find it fulfilling. I chose to go to law school, and I really became interested in the civil rights courses that were offered. After I graduated, I did clerk for a year. And again, that was when it sort of opened my eyes up to how difficult it can be for individuals to pursue a claim in our judicial system. And so, right after I went to work for a small law firm that did education law, represented students in schools, and similar to what I do now, it's another motive of sort of standing up for yourself and making sure that you're treated fairly and appropriately in both the school as well as in the workplace.
So, how did you know? It sounds like, did you know you wanted to go to law school when you were still an undergrad, or how and when did you know you wanted to be an attorney?
Didn't. I did not know when I was an undergrad. I think I didn't really realize that until I was out there working for a while, and I realized I wanted to have a job that was a little bit less transactional, a little bit more face to face with people, changes daily. And I think that's normal. I think that a lot of people take time off after college. They don't know exactly what they want to do. You go out in the working world and you try on a bunch of different shoes and see what fits before you really decide to go into law school. And I think it makes you a better law student to go in there with a mindset of what you want to do with the degree.
I feel like I'm still trying on shoes, and it's been like decades since I was an undergrad. What were the early days of your legal career like then? You said you were a clerk. What about as a lawyer? What were the early days like?
Um, it's I think the early days are just a lot of learning. There's just particularly in litigation, there are just so many facets to it. And as much as you just want to get in there and you want to get your own case, um, looking back on it, it's important to realize that the person you're representing, you may have 25, 30 cases on your caseload, but the person you're representing, this is the most important thing going on to them. And making sure that dot your I's and cross your T's and know not only the procedures of the court you're working with, but the law that you're working with and all the rules that apply and discovery. It's really important to have good mentors, which I've luckily always had in the workplace, and have people that also bring you behind the curtain and show you what they're doing and show you how they're doing things and explain to you why they're doing things. But those early days are really important to attach yourself to some attorneys who can show you the ropes. And that way, when you are able to start with your own cases, you've seen what's going on, you know what to do. And you also feel comfortable going back to people to ask what to do. I'm still learning. I wouldn't say I know everything. Laws are constantly changing. Um, and so I'm often talking to my colleagues, hey, what do you do when you have this type of case? How have you moved this forward? And I think in the early days, having that mindset of just knowing that there's a lot more to learn after law school is really important.
Sure. Take me through a little bit of your journey toward becoming a partner with Swartz Swidler. How did that come about?
I was there for about 6 or 7 years before that occurred. So, like I said, I was really just an associate that did a lot of the grunt work, a lot of drafting things, a lot of taking the short calls with the court for the partners and the higher level attorneys. And slowly I started helping with more discovery, started sitting in on depositions, defending some depositions, and grew into having my own caseload. And, career just progressed from there until the time where it felt like I was comfortable enough to run with my own caseload. That said, still rely a lot on my colleagues, and I'm not out there doing it on my own.
What at the risk of putting you on the spot, who's kind of been a mentor for you, and what have you learned from that person, or those people? Maybe some advice or just observation from watching them work.
Sure. I would say the best mentor I've had in my career is Judge Kathy Surratt, who I clerked for right after law school. She really did a great job of explaining why she made decisions, explaining to me why when I did things that she disagreed with, or when I drafted briefs for her that she made changes to, going through and redlining and showing me the changes that she made. It seems extremely tedious, but I felt like by the time I left my clerkship and I was going into the world of litigation, I had an idea on the other side arguing against judges as to what they were thinking and what really did move the court and what the court wanted to see. So she was an excellent starting point, and I felt, I think, much more prepared to start my career than I would have had I not clerked. Continue to ping her today on just questions about navigating your career as a mom, as a female, just as a lawyer in general. So she's been a wonderful mentor. Also, when I joined the firm, the two founding partners, Richard Swartz and Justin Swidler, have always been very good about ensuring that anyone they bring into the firm gets a lot of experience right off the bat. They don't just stick you in a dark corner of a room and have you churn out data. They really are happy to bring you along, happy to have second chairs at trials and someone sitting in on depositions. And so that really, coming in there with the clerkship knowledge, but having them bring me along really helped me get to a point where I was comfortable.
Is there anything else we need to know about employee litigation if somebody's feeling uncomfortable in their jobs or they're feeling discriminated against or harassed? Any general advice?
My best advice is, always phrase it as a question, but you're welcome to go to your human resources. If you genuinely believe there's an issue in the workplace, it is best to speak up. You don't have to be combative. You don't have, if that's not, you don't have to claim you're going to sue an employer. But if you feel like you are being treated differently because of some issue, race, religion, and upcoming surgical leave or leave for surgery, it's always best to speak up. And as I said, follow it up in writing so that you've clarified your position so that nobody can say, that's not what I thought you said. It's always good to ask, even if you're wrong. At least that way you're wrong.
Sure. Hey, I have one more question for you, but tell me how people can find out more about Swartz Swidler.
It's just on our website, swartz-legal.com. We've got lots of articles up there about changes in case law, cases that we've brought that we think highlight things that employees need to know, and sometimes class actions that we are bringing that employees it might be an employer that they want to join. So easy to
was
find
there
us.
yeah, great. Was there ever throughout the course of your career, like a moment where you were like, this has been a big turning point for me, like maybe you won a case or something, like, okay, I'm established, my confidence was just boosted from a certain moment?
It's hard to say. I don't know if I've ever had an exact moment. I think it's just been a slow growth over time where, the third time you go into court for a trial, you realize, okay, the first time I messed this up, I know I want to correct this. I know I want to correct this. I think it's just your comfort level grows over time as you get more experience. But I don't know if I ever had a moment that was an exact turning point.
What's it like going into your first trial case?
A little while ago. I mean, the very first trial is just very nerve-wracking. It's chaotic. You wonder, trials don't happen often in employment litigation. 99% of cases settle.
Okay.
And so as an attorney, you could go years without actually going to your very first trial. And so you're always prepping for trial, but most cases settle. And so that very first time where you actually have to go to trial and you got to get jury instructions and you have to have the big binders of exhibits. And now you're not just worried about your case, you're worried about tech and picking a juror. And there's just so much more that jumps onto your plate. It's incredibly nerve-wracking. But I think as you do it more often, your comfort with it grows and your expectations of what's going to happen come into play. And now it's I'm not saying it's not nervous. I think every attorney is nervous and should be nervous. Trial's a big deal, but it's not as nerve-wracking.
Great. Hey, Manali, it's been great to talk to you today. Thank you so much. Really appreciate your time.
Thank you. Bye-bye.
So long, everybody. Thanks for listening to 15 Minutes. Be sure to subscribe, and we'll see you next time.